Oklahoma High School Mock Trial Program, 2019 to 2020. State of Oklahoma versus Kristen Taylor. Witness and exhibit list. The following witnesses shall be called by the parties. For the prosecution, Francis Baykon, Lieutenant Marty Pacheco, Dakota Griffin, MD. For the defense, Logan Taylor, Madison James, MD, PhD, Taylor McGraw, MD. The following exhibits may be used by the teams in competition. They are pre-marked and are to be referred to by number as follows. Exhibit number 1, the accident report. Exhibit number 2, supplementary offense report. Exhibit number 3, okay, I can't read this. The resume of Dakota Griffin. There you go. Exhibit number 4, resume of Madison James, MD, PhD. Exhibit 5, Automobile Consumer Utility Safety Department report. Exhibit 6, resume of Taylor McGraw. Exhibit 7, excerpt of study. Stipulations. The parties have stipulated to the following: jurisdiction, venue, and chain of custody of the evidence are proper. The applicable law is contained in the jury instructions. These may not be read into the record. Pleadings and jury instructions may not be objected to at the trial. All exhibits are authentic. Their authenticity may not be challenged unless stated otherwise. Admissibility of exhibits may be challenged on other grounds. 4. The witnesses gave their statements as indicated in the case. Each witness was given the opportunity to review the statement prior to and in let me zoom in, hold on. I can't, whoops. Preparation for the trial. All statements made by witnesses and all physical evidence and exhibits were constitutionally obtained. Okay, it's really hard to read these tiny words, bro. Whether a rule of evidence requires that reasonable notice be given, it has been given. Defendant Kristen Taylor has elected not to testify in her defense. Coincidentally, her role will not be portrayed at the trial, because she is neither an attorney nor a witness in the case. The medical treatments of Kristen Taylor and Baby Doe may be discussed by the witnesses, but the actual records will not be introduced into evidence. This trial is solely for the determination of guilt. The jury must not consider the penalty for conviction of a crime. Statement of facts. This is intended as a summary only and not to be used as evidence in the trial. Kristen Taylor graduated from Roosevelt High School in Big Cabin, Oklahoma on May 29, 2018. She was 17 years old and an active and successful student who had received a scholarship to Stanford University. Taylor was also 7 months pregnant and was expected to give birth at the end of July 2018. It was her intent to give up the child for adoption. Following the graduation ceremony on May 29th, Taylor attended a party that evening at the home of another 2018 RHS graduate, Blake Colvin. Interesting name. Unbeknownst to Miss Colvin's parents, a keg of beer and some cases of bottled beer had been hidden in a storage building behind their house. Several of the guests, including Taylor, visited the storage building during the party to partake of the alcohol. During the party, some of the graduates, including Taylor, decided to drive to Grand Lake to watch the sunrise. At approximately 10:30 p.m., Taylor left the lake alone in her sport utility vehicle, a 2015 Isuzu Gazelle, driving south on the Will Rogers Turnpike, where the speed limit varied, depending on location, between 65 miles per hour and 75 miles per hour. A little more than an hour later, approaching Big Cabin, Oklahoma, and still on the turnpike, Taylor lost control of the vehicle, struck the center concrete barrier, and rolled over. Lieutenant Marty Pacheco, who had been proceeding north on the Will Rogers Turnpike, had turned around to follow Taylor after she had passed him, driving, according to his/her testimony, erratically and at a high rate of speed, was first to arrive at the scene of the accident. She/he administered a field sobriety test, which Taylor failed, and 3 breathalyzer tests with results of .04, .07, and .08. Taylor was transported by ambulance to Eastern Oklahoma Memorial Hospital, where her baby was delivered by emergency C-section at about 5:30 a.m. on May 30th, 2018. The 4.5-pound boy, Baby Doe, died 2 days later. Cryogenetic testing confirmed that he had been born with trisomy 13, a chromosomal disorder that causes severe mental retardation, physical abnormalities, and often death. Taylor had been charged by the Craig County District Attorney with negligent homicide in the death of her son. At trial, the prosecution will call Francis Baykon, a friend of Taylor's, who will testify that Taylor drank alcohol at the graduation party. Lieutenant Pacheco, who will testify that Taylor's intoxication and recklessness caused the accident, and Dr. Dakota Griffin, who will testify that the accident caused the death of Baby Doe. The defense will call the defendant's brother/sister, Logan Taylor, who will testify that Taylor was not impaired when she left Grand Lake. Dr. Madison James, who will testify that the accident was not caused by Taylor's drinking, but by the instability of the vehicle she was driving. And Dr. Taylor McGraw, who will testify that Baby Doe's death was not caused by the accident, but his birth defect. All events, characters, and documents created for the 2020 case are fictional. In the district court in and for Gregg County, State of Oklahoma. Plaintiff versus Kristen Taylor, defendant. Case number CF-2018-168. Information. In the name and by authority of the State of Oklahoma comes now Stan Lee, the duly elected, qualified, and acting district attorney and for Gregg County, State of Oklahoma, and on his official oath informs the court that, count 1, on or about the 29th day of May 2018, the crime of negligent homicide was wrongfully committed in Craig County, Oklahoma by Kristen Taylor, who negligently caused the death of Baby Doe by operating a motor vehicle while under the influence of intoxicating liquor or in reckless disregard for the safety of others. Stanley District Attorney, November 12, 2018. The names of the witnesses endorsed for the state of Oklahoma are as follows: Francis Baykon, Lieutenant Marty Pacheco, Dakota Griffin, MD. Legal authorities. Oklahoma Statutes Title 47, Section 11-903, Negligent Homicide. When the death of any person induces within 1 year as a proximate result of injury received by the driving of any vehicle by any person in reckless disregard of the safety of others, the person so operating such vehicle shall be guilty of negligent homicide. B. Any person convicted of negligent homicide shall be guilty of a misdemeanor punishable by imprisonment in the county jail for not more than 1 year, or by fine of not less than $1,000, or by both such year and imprisonment. Oklahoma Statutes Title 47, Section 11-901, Reckless Driving. A. It shall be determined reckless driving for any person to drive a motor vehicle in careless or wanton manner without regard for the safety of persons or property, or in violation of the conditions outlined in Title 47, Section 11-801. Oklahoma Statutes Title 47, Section 11-801. Speed Restrictions Basic Rule. A. Any person driving a vehicle on the highway shall drive the same at a careful and prudent speed, not greater nor less than is reasonable and proper, having due regard to the traffic, surface, and width of the highway, and any other conditions then existing. No person shall drive any vehicle upon a highway at a greater speed than will permit the driver to bring it to a stop within the assured clear distance ahead. B. Except when a special hazard exists that requires lower speed for compliance with the subsection A of this section, the limits specified by the law or established as hereinafter authorized shall be maximum lawful speeds, and no person shall drive a vehicle on a highway at a speed in excess of the maximum limits. C. The Oklahoma Turnpike Authority is hereby authorized to prescribe maximum and minimum speeds for trucks, buses, and automobiles using turnpikes. Such regulations shall become effective only after approval by the Commissioner of Public Safety and after signs have been posted on the turnpike giving notice thereof. Such regulations may apply to an entire turnpike project or selected sections thereof as may be designated by the Oklahoma Turnpike Authority. It shall be a violation of this section to drive a vehicle at a faster rate of speed than such prescribed maximum speed, or at a slower rate of speed than such prescribed minimum speed. However, all vehicles shall at all times conform to the requirements of subsection A of this section. D. The driver of every vehicle consistent with the requirements of subsection A of this section drive at an appropriate reduced speed when approaching a crossing, an intersection, or railway grade crossing, when approaching and going around a curve, when approaching a hill crest, when driving upon a narrow or winding roadway, and when special hazards exist with respect to pedestrians or other traffic, or by reason of weather or traffic or highway conditions. The Oklahoma Department of Transportation and the Oklahoma Turnpike Authority may post bi-changeable signs or other appropriate sign of temporary reduced speed for maintenance operations, or when special hazards with respect to pedestrians, other traffic, and accident by reason of whether or when hazardous highway conditions exist. E. Any person convicted of a speeding violation pursuant to this section shall be punished by a fine. Oklahoma Statutes Title 47, Section 11-902. Persons under the influence of alcohol or other intoxicating substance or combination thereof. A. It is unlawful and punishable as provided in this section for any persons to drive, operate, or be in actual physical control of a motor vehicle within the state, whether upon public roads, highways, streets, turnpikes, other public places, or upon any private road, street, alley, or lane which provides access to one or more single or multi-family dwellings who 1. Has a blood alcohol or breath alcohol concentration of 0.08 or 0.08 or more at the time of a test of such person's blood or breath administered within 2 hours after the arrest of such person. 2. Is under the influence of alcohol. 3. Has any amount of Schedule 1 chemical or controlled substance or one of its metabolites or analogs in the person's blood, saliva, urine, or any other bodily fluid at the time of test of such person's blood, saliva, urine, or any bodily fluid administered within 2 hours after the arrest of such person. 4. Is under the influence of any intoxicating substance other than alcohol which may render such person incapable of safely driving or operating a motor vehicle, or is under the combined influence of alcohol and other intoxicating substance which may render such person incapable of safely driving or operating a motor vehicle. B. The fact that any person charged with a violation of this section is or has been lawfully entitled to the use of alcohol or a controlled dangerous substance or any other intoxicating substance shall not constitute a defense against any charge violating this section. Oklahoma Statutes, Title 47, Section 751. Implied consent to breath, blood, or other test for determining concentration of alcohol or other intoxicating substance. A. 1. Any person who operates a motor vehicle within the state shall be deemed to have given consent to a test or tests of such person's blood or breath for the purpose of determining the alcohol concentration if arrested for any offense arising out of facts alleged to have been committed while the person was operating or in actual physical control of a motor vehicle while under the influence and any other intoxicating substance or injury of any party, and is removed from the scene of the accident to a hospital or other healthcare facility outside the state of Oklahoma before law enforcement can effect an arrest. 2. A law enforcement officer having reasonable grounds to believe that such a person was operating or in actual physical control of a motor vehicle while under the influence may direct the administration of or administer the tests or tests. As used in this title, the term other intoxicating substance shall mean any controlled dangerous substance as defined in the Uniform Controlled Dangerous Substances Act and other substance other than alcohol which is capable of being ingested, inhaled, injected, or absorbed into the human body and is capable of adversely affecting the central nervous system, vision, hearing, or other sensory or motor functions. B. Law enforcement agency by which the arresting officer is employed may designate in accordance with the rules of the Board of Tests for Alcohol and Drug Influence, hereinafter referred to as the Board, whether blood is to be or breath is to be tested, for the alcohol concentration thereof, and whether blood, saliva, or urine is to be tested for the presence or concentration of any other intoxicating substance therein. C. In the event the person is incapable of submitting to or successfully completing by reason of illness or injury or other physical disability the test to be administered, an alternate test may be administered in accordance with the rules of the board. D. Any person who is unconscious or otherwise incapable of refusing to submit to a test of such person's blood or breath to determine the alcohol concentration thereof, or to a test of such person's blood, saliva, or urine to determine the presence or concentration of any other intoxicating substance therein, shall be deemed not to have withdrawn the consent provided by subsection A of this section, and such test may be administered as provided herein. E. In addition to any test designated by the arresting officer, the arrested person may also designate any additional test to be administered to determine the concentration of alcohol or the presence or concentration of any other intoxicating substance, or the combination of alcohol and any other intoxicating substance. The cost of such additional tests shall be at the expense of the arrested person. F. When the law enforcement officer has determined that the blood alcohol content of an individual is to be tested, the presence or concentration of alcohol or other intoxicating substance, or the combination of alcohol and any other intoxicating substance, the law enforcement officer shall inform the individual to be tested that the withdrawal of blood shall only be performed by a certain medical personnel as provided for in Section 752 of this title. Oklahoma Statutes Title 47, Section 756. Admission of evidence shown by test. A. Upon the trial of any criminal action or proceeding arising out of acts alleged to have been committed by any person while driving or in actual physical control of a motor vehicle while under the influence of alcohol or any other intoxicating substance, or the combination of influence and alcohol and any other intoxicating substance, evidence of the alcohol concentration in the blood or breath of a person as shown by analysis of the blood or breath of a person is admissible. Evidence that the person has refused to submit to either of said analyses is also admissible. 1. Evidence that there was, at the time of test, an alcohol concentration of 0.05 0.05 or less is prima facie evidence that the person was not under the influence of alcohol. 2. Evidence that there was, at the time of the test, an alcohol concentration in excess of 0.05 but less than 0.08 0.08 is relevant evidence that the person's ability to operate a motor vehicle was impaired by alcohol. However, no person shall be convicted of the offense of operating or being in an actual motor vehicle control of a motor vehicle while such person's ability to operate such vehicle was impaired by alcohol solely because there was, at the time of test, an alcohol concentration in excess of 0.05 but less than 0.08 in the blood or breath of a person in the absence of additional evidence that such person's ability to operate the vehicle was affected by the alcohol to the extent that the public health and safety was threatened, or that said person has violated a state statute or local ordinance in operation of a motor vehicle. This water's really good, boys. 3. Evidence that there was, at the time of the test, an alcohol concentration of 0.08 0.08 or more shall be admitted as prima facie evidence that the person was under the influence of alcohol. For purposes of this title, alcohol concentration means grams of alcohol per 100 milliliters of blood if the blood was tested, or grams of alcohol per 210 liters of breath if the breath was tested. C. To be admissible in proceeding, the evidence must first be qualified by establishing that the test was administered to a person within 2 hours after the arrest of the person. Jury instructions. From Oklahoma Uniform Jury Instructions, Criminal. OUJICR 459. Homicide Introduction. The defendant is charged with the negligent homicide of Baby Doe on or about May 29, 2018 in Craig County, Oklahoma. OUJICR 4-105. Negligent homicide elements. No person may be convicted of negligent homicide unless the state proves beyond a reasonable doubt each element of the crime. These elements are: first, the death of a human; second, caused by the defendant's driving a vehicle upon a highway; third, in reckless disregard for the safety of others; fourth, the death occurred within a year of infliction of the injury causing death; 5. The defendant was 16 years of age or older. OUJICR 4-106. Negligent homicide. Highway defined. A highway is the entire width between the boundary lines of every publicly maintained when any part thereof is open to the use of public purposes of vehicular travel. OUJI-CR 4-107. Negligent homicide. Reckless disregard defined. Reckless disregard of the state of others is the admission to do something which a reasonably careful person would do, or the lack of the usual ordinary care and caution in the performance of an act usually and ordinarily exercised by a person under similar circumstances and conditions. OUJI-CR 4-60. Homicide causation. No person may be convicted of negligent homicide unless her or their conduct caused the death of the person allegedly killed. A death is caused by the conduct if the conduct is a substantial factor in bringing about the death and the conduct is dangerous and threatens or destroys life. OUJI-CR 914. Necessity for cooperation in homicide case. No person may be convicted of negligent homicide unless both the fact of death of the person allegedly killed and the fact that his death was caused by the conduct of another person are established as independent facts and beyond a reasonable doubt. OUJI-CR 624. Driving under the influence. Chemical test evidence defined. If you find that a chemical analysis of the defendant's breath was performed on a sample taken from the defendant within 2 hours of the accident, then the results of this analysis may be considered by you as to the issue of whether the defendant was under the influence of alcohol. If you are convicted that the amount or if you are convinced that the amount of alcohol by weight or volume in the defendant's blood was 0.08 of 1% or 0.08% or greater, then you may find the defendant to have been under the influence of alcohol. If, however, after considering the chemical analysis together with all other evidence in the case, you entertain a reasonable doubt as to whether the defendant was under the influence, then you should find her not to have been under the influence of alcohol. OUJI-CR 9-1. Inferences. You should consider only the evidence introduced while the court is in session. You are permitted to draw such reasonable inferences from the testimony and exhibits as you feel are justified when considered with the aid of the knowledge which you each possess in common with other persons. You may make deductions and reach conclusions which reason and common sense lead you to draw from the fact which you find to have been established by the testimony and evidence in the case. OUJI-CR 944. Defendant's right not to testify. The defendant is not compelled to testify, and the fact that the defendant does not testify cannot be used as an inference of guilt and should not prejudice her in any way. You must not permit that the fact to weigh in the slightest degree against the defendant, nor should this fact enter into your discussions or deliberations in any manner. OUJI-CR 10-8. Credibility of a witness. It is your responsibility to determine the credibility of each witness and add the weight to be given the testimony of each witness. In determining such weight or credibility, you may properly consider the interest, if any, which the witness may have in the result of the trial, the relation of the witness to the parties, the bias, the prejudice of the witnesses. It has been apparent the candor, fairness, intelligence, and demeanor of the witness, the ability of the witness to remember and relate to past occurrences, the means of obstruction, and the opportunity of knowing the matters about which the witness has testified from all the facts and circumstances appearing in evidence and coming to your observation during the trial, aided by the knowledge which you each possess in common with other persons. You will reach your conclusions. You should not let sympathy, sentiment, or prejudice enter into your deliberations, but should you discharge your duties as jurors impartially, conscientiously, and faithfully under your oaths, and return such verdict as the evidence warrants when measured by these introductions. OUJI-CR 942. Credibility of opinion witnesses. Testimony has been introduced of certain witnesses who purport to be skilled in their line of endeavor, or who possess particular knowledge acquired by study, observation, and practice. You may consider the testimony of these witnesses and such it weigh and value as you think it should have, but not weight and value to be given their testimony is for you to determine. You are not required to surrender your own judgment or that of any person testifying based on the person's education, training, or experience. You need not give controlling effect to the opinion of such witnesses, for their testimony, like that of any other witness, is to be received by you and given such weight and value as you deem it entitled to receive. OUJR OUJI-CR 10-4. Presumption of innocence. The defendant is presumed innocent of the crime charged, and the presumption continues unless, after consideration of all the evidence, you are convinced of her guilt beyond a reasonable doubt. The state has the burden of proof, presenting the evidence that establishes guilt beyond a reasonable doubt. The defendant must be found not guilty unless the state produces evidence which convinces you beyond a reasonable doubt of each element of the crime. Finally, after all that reading, the moment you've all been waiting for, the first statement of the case. Statement of Francis Baykon. My name is Francis Baykon. I live at 16 Arthur House Road in Big Cabin, Oklahoma, and have lived in that house since I was a little kid. In May of 2018, I graduated from Roosevelt High School. Until about 3 months before graduation, Kristen Taylor and I were very close friends. We both ran track, we were in band together, and we served on the RHS Student Council during the fall semester. We even worked on the school newspaper when Kristen was the editor. We had known each other for years because we went to the same elementary school and middle school. And she and my brother Tony dated each other exclusively the whole time she was in high school. Or at least, that's what Tony and I thought. Then in March, we learned that Kristen was pregnant, and Tony said he knew for a fact he was not the father. Not that this was in dispute or anything, Kristen never said he was. Anyway, I was pretty ticked off at first, because she made a fool of him. You think you're the only person someone is dating, and then she gets pregnant by someone else. I mean, how embarrassing is that? It wasn't long, though, before Tony started seeing someone else, and he and Kristen remained friends. Sort of. He was going to Rogers State University by this time, so he met loads of new people and made new friends. I decided that if it didn't bother him, it shouldn't bother me. I called Kristen a couple of times in 1 week to make arrangements to get together with her, but she didn't call me back. I figured she was still mad at me for those things I said to her, and when she told Tony and me that she was pregnant, so I went over to her house to apologize. She answered the door herself, and I told her that I was sorry for yelling at her and calling her names. I explained that I was just defensive because she had cheated on Tony. I reminded her of how she would feel that if someone had done this to her sister/brother, and she agreed that she would have been way mad also. She said she understood completely about family members protecting each other, so we sort of hugged, and that was that. Even though we had made up, we didn't go back to the same kind of closeness we had shared before, but we did okay. She talked with me some about the pregnancy, although she never did tell me who the father was. Only that he didn't know the baby was his and that she wasn't going to tell him. She had been accepted into Stanford, and it was her plan to give the baby up for adoption. Nothing, she said, was going to interfere with her going to college. There was no adoptive parents standing in the wings or anything like that. She was just going to go through some agency. I remember thinking that it was a good thing for her parents had given her their 2015 Suzu Gazelle Gazelle. Well, the one car. We're gonna say ZG, cause yup, the year before, because they for sure wouldn't have bought her that car if after she got pregnant. They were so mad at her, they threatened to take the car away, but she convinced them that she needed it to take her and her sister/brother to school and to go to the doctor. Yeah, right. She didn't even go to the doctor until she was nearly 4 months along. She said it was because she didn't want her parents to find out she was pregnant, but I think she just didn't give a rat's what about the baby. And then, when she finally did go, she didn't tell the doctor the truth about some things. By that, I mean, even after she knew she was pregnant, Kristen still drank and smoked occasionally. I know years ago no one knew that it was bad for pregnant people to do that, but nowadays everyone knows that the better care the mother takes herself, the better off the baby will be. I don't mean to say that Kristen was a chain smoker or an alcoholic or anything. I said occasionally, and that's what I meant. It just seemed to me that if Kristen really cared anything at all about the baby, she would be more responsible and less selfish. Sometimes, after school, she would nag and nag to go with me to my house to party. She would tell her parents some lie, and then off we'd go. Both of my parents worked, and Tony was at college, so I had free reign of the house, including the refrigerator and the bar. We drank at my house every couple of weeks, but fortunately my parents never seemed to notice that the liquor was missing. They bought everything by the case at one of those warehouse stores and kept it out in the garage. I guess when you buy in quantity, you don't really pay attention to what's going on. I always tried to discourage Kristen from drinking, but mostly most of the time of the she time, most that's a typo. But most of the she time didn't have all that much, and she said she really needed it to relax. Yeah, so I went along with her. On the graduation night, a friend of ours named Blake Colvin was having a party. There was probably 30 or 40 people there. The music was great. Everyone was dancing. Even Kristen got out and danced a few times. I noticed that people were going around the back of the house to use the storage building, so I went out there too. Inside was a keg with a tap and about 4 or 5 cases of bottled beer. There was also cases of a couple of kinds of sodas. Blake's parents were home, so I couldn't believe there was all this alcohol. But she generally did whatever she wanted, so I guess it wasn't all that surprising. Her mom had made these great snacks and food for us, and people were really pigging out. Not Kristen, though. Whenever I saw her, she was drinking, not eating. Oh, I take that back. One time I did see her eating some of the pizza Blake's mom had made. About 10:30 or so, someone suggested that we drive to Grand Lake to watch the sunrise. I can't remember whose idea it was, but I do remember thinking that it was insane since people had been drinking. Besides, it was late, everyone was tired, but they didn't care what I thought, and they all decided to go anyway. They went in 4 cars. For some reason, Kristen was the only one in the Gazelle. The G, dude, she was in the G, alright, the car. She was in the car, okay? I couldn't understand why she didn't just ride with someone else. Before they left, I noticed that Kristen went out back again, and I didn't know what she was doing, but I really hoped she wasn't getting any more beer. If I followed her and asked her about it, she told me to mind my own business. I watched her for a while, but I didn't see her drink any more beer. I went into the house to get my jacket, and as I walked out to my car to go home, I saw Kristen getting into the car. She was carrying a 6-pack of some kind of bottles, but I couldn't tell what they were. There were bottles of beer and the soda
or there were bottles of beer and soda in the storage building, though. And if it had been soda, why was she so paranoid when I asked her why she had gone out back again? I heard a couple of days later that Kristen had rolled the G, the car. I thought to myself, well, that's what happens when you drink and drive. But then I found out that she had the baby and it died. So I felt bad about what I had thought then. I felt even worse when I heard that the kid really had a bunch of stuff wrong with it. Some kind of deformity thing or something. Now, she's been charged with killing her kid, which is really awful of her. I can't help thinking, though, if she had cared about it, she would have taken better care of herself while she was pregnant. And she wouldn't have drunk beer and tried to drive herself to Grand Lake that night. That seems so irresponsible to me. Witness addendum. I have reviewed this statement and I have nothing of significance to add. The materials and facts are true and correct. Signed, Francis Bacon. Francis Bacon. Signed and sworn to before me at 8 a.m. on the 31st day of October 2019. Molly Madston, Notoriety Public of Oklahoma. My commission expires November 1st, 2021. Statement of Marty Pacheco. I literally don't know how to pronounce this name. My name is Marty Pacheco. I am currently a lieutenant with the Oklahoma Highway Patrol, and I am stationed in Ventita, Oklahoma. I was born on October 15th, 1970 in Omaha, Nebraska. Originally, my parents were from Nebraska, but in 1965, the state of Nebraska hired my dad, who was an engineer, to help me design a new expressway. To help design a new expressway. So they moved. I attended 2 years of college at the University of Nebraska, and then in 1990 I joined the Merchant Marines. While I was in the military, I attended some additional college courses, but I never did get a degree. I left the military service after 5 years and relocated to Oklahoma in 1996. I applied to the Oklahoma Highway Patrol Academy, and I was accepted. Upon graduation, I was stationed in Vinita, and in 1998 I married my spouse. We have one child, a son named Jason. Unfortunately, when he was 6 years old, he was struck and permanently disabled by a drunk driver whose blood alcohol concentration was measured at 0.35, more than 3 times the legal limit. The drunk driver walked away, but Jason will never walk again. He'll be in a wheelchair for the rest of his life. One of the most unfortunate aspects of the incident was that the driver had been arrested for 4 previous occasions of DUI. The last time was only 6 months before he hit Jason. He shouldn't have been on the road. I became convinced that DUI was a plague in Oklahoma and it had to be stopped. I requested and was granted the opportunity to participate in the Operation DUI Community Coordination and Visibility Program. Our mission was to coordinate police activities and state and community immediate advocacy. I have some big word, hurt my brain. And publicity. Oh my gosh, publicity efforts to ensure the effectiveness and visibility of law enforcement efforts during the implementation of Operation DUI. After that, I participated in Operation DUI Checkpoint Enforcement Program, which conducts specialized DUI enforcement operations on a statewide basis. I've been on loan to various local police departments throughout the state to assist them in drug recognition expert development program, which utilizes the National Highway Traffic Safety Administration's approach to increase the apprehension of persons driving while impaired by drugs other than alcohol. I am also a frequent contributor to a monthly newspaper and quarterly traffic safety forums managed by the Institute of Public Law. For the past 2 years, I have served as a consultant for the State of Oklahoma Highway Traffic Office, advising on the Governor's Impaired Driving Prevention Advisory Council, which offers a program to encourage local police to conduct underage alcohol sales enforcement using cops in shops and other sting approaches. I will do everything I can to get drunk drivers off the road. They are a menace and should have been treated like the criminals they are. So during the past year and a half, I focused my full attention on becoming an expert in the area of breath alcohol testing. In Oklahoma, all breath alcohol analysis are performed by direct blood testing, an into-exhalyzer 8D. I guarantee you I said that wrong. Which evidently in nature, evidence devices provide information that can be used as evidence in court. Screenings devices, field sobriety tests, may be used to develop probable cause to arrest for DUI and or justification for further DUI testing. The Board of Tests for Alcohol and Drug Influence, BTAD, as we call it in the field, as we in the field call it, of the Oklahoma Department of Public Safety, is the agency that issues regulations that govern the certification of labs, breath alcohol testing instruments and individuals, and the methods of taking and analyzing samples of blood and breath testing for alcohol and or other chemical substances under the Oklahoma Applied Consent Act. The DPS, through the BTAD regulations, requires that breath samples must be analyzed by certified operators of key operators on equipment and instruments approved by the BTAD. The testing instruments are certified for 1 year by the BTAD, and those certifications expire annually on September 30th. Prior to initial certification and twice a year thereafter, BTAD will schedule and conduct calibration tests and inspections of the instruments. If the instrument does not meet the BAT established criteria, they won't certify it, or if it was previously certified, they will revoke or suspend the certification. I have been a BTAD certified operator for more than 1 year and a BTAD certified key operator for 5 months. In order to be a certified operator, you have to have a full-time salarized peace officer in Oklahoma, and you have to provide proof that to BTAD that you have completed training provided by BTAD certified instructors. The training must include, but is not limited to, the value and purpose of blood and breath alcohol testing, the effects of alcohol in the human body, the methods of the alcohol analysis and theory of breath testing, the breath alcohol testing instruments and procedures for breath testing, practical experience and demonstration of
and the Oklahoma Implied Consent Act regulations and any amendments and or revisions and court testimony. In addition, you have to complete successfully comprehend you have to complete successfully comprehensive practical and written examinations. To be a key operator, the person who performs the weekly calibration checks the breath testing equipment. You have to be a certified operator on the type of equipment for which you are seeking key operator status, and you have to take additional training that includes, but is not limited to, the theory of breath testing, the operational and theoretical principles of the selected breath testing equipment, the preparation and use of a simulator calibration checks or selected breath alcohol testing instruments, quality control measures and proficiency testing, minor maintenance and repair breath alcohol testing equipment for the Oklahoma Implied Consent Act regulations and amendments and or revisions and court testimony and labor practice and the demonstration of competency. Oh, I just lost my spot. That's just fantastic. Competency on the applicable equipment, and like with being certified as an operator, you have to successfully complete comprehensive practical and written examinations. To get my certifications as an operator and key operator, I had to go through a total of 16 hours of training. Wow, just 16 hours. I had to pass 2 tests. You can see that I am achieving my goal of becoming an expert in breath alcohol analysis. Once I have completed an additional 32 hours of training and passed another test, I can become an operator instructor and teach others how to be operators and key operators. No, more witness statement. I remember May 29th, 2018 very well. I was on duty working the 7 p.m. to 3 a.m. shift out of Vinita. Late spring is always a difficult time of year because school lets out and there's a dramatic increase in the amount of traffic on highways. You know, families take vacations and high school and college kids are out partying. A great deal of drinking goes on. So it's a really busy time for us. Why, during the past week in question, I have been called to 7 DUI stops on Will Rogers Turnpike between Vinita and Miami. At about 11:20 p.m., while I was making a run from Vinita to Miami, I passed an SUV, a sport utility vehicle that was proceeding erratically, heading south in the opposite direction. The vehicle was wavering, going from lane to lane, passing other cars, and even though I was unable to get a radar gun of it, I'm sure the driver was speeding as well. I notified dispatch that a dark-colored SUV was proceeding south at a high rate of speed, and that I believed the driver to be drunk. I looked at the first median I could find where I could cross over and head south. I was traveling approximately 95 miles per hour in an effort to catch the SUV. Fortunately, traffic was not very heavy, so I was able to stay in the left lane. Only a few cars had to get out of my way. The flashing lights on the unit were very easy for them to see in the dark, and they had moved over without incident. It took about 2 or 3 minutes before I could actually see the SUV. When I was about a quarter of a mile behind it, the driver suddenly swerved struck the center concrete barrier, and rolled the vehicle 2 or 3 times. I reached the accident scene within seconds. The first thing I remembered was getting out of my unit, the first thing I remember about getting out of my unit was how windy it was. A gust from the northwest caught me by surprise and almost knocked me over. I think it must have been gusting to about 35 miles per hour or so. I ran over to the SUV, which turned out to be a 2015 navy blue ZG 4x4. It was pretty well banged up, but I could see that before the wreck it had been in good shape. I had heard these vehicles were top heavy and prone to rolling over, but I didn't buy it. I was sure that the accident was a result of the driver being drunk and driving recklessly. The driver was a female who appeared to be around 17 or 18 years old. She was conscious and when I asked if she was injured, she started crying. My baby, my baby. I thought she meant there was a child in the vehicle, so I checked both front and back seats. I did not see anything in the car but a 6-pack of beer with 2 bottles missing, and I looked back at the driver. I saw she was pregnant, so I figured she was referring to that baby. I asked the driver her name. She told me that it was Kristen Taylor. Again, I asked if she was injured, and she said she wasn't. I unhooked her seatbelt and asked her to step out of the car. She seemed disoriented and confused. Her eyes were red. Her speech was slurred, and she was sort of staggered. Staggered. When she walked, I could see that her forehead was bleeding and her left eye looked swollen. But when I got close, I smelled alcohol. It was a strong odor, and I think it was beer. I looked again in the vehicle, but I didn't see any empties, and there were no other cans or bottles. Let me get some water, boys. This is a really, really long testimony. And there's still a full page and a half of it, so let's keep going. Okay. Since she was pregnant, it seemed she would need to be looked at by a doctor, so I went to my unit and called for an ambulance. I got a gauze pad from my first aid kit and told her to hold it on the cut on her forehead. Fortunately, the cut stopped bleeding almost immediately. After observing her for a few minutes, I asked her to take a field sobriety test, which she failed. I videotaped her taking the test, but somehow the tape was lost. That's interesting. She couldn't walk a straight line, or touch her nose, or count to 10. I waited the required 20 minutes, during which time I observed her constantly, and then I administered breathalyzer tests. The second 15 minutes after the first test showed her to be a .04. The second had her at .07. The regs say that if the difference between the two tests is more than .02 grams of alcohol per 210 liters of breath, then the third sample must be collected. I then collected the third sample, almost immediately, which measured .08, the legal limit. Oh no. At this time, 3 other vehicles loaded with teenagers arrived. Among with the ambulance I had called for, the kids were not intoxicated, or at least they didn't seem to be. One of them had told me they had been at a graduation party with Ms. Taylor, and they had been at Grand Lake to watch the sunrise. At about this time, Miss Taylor began to moan and fell to the ground. I rushed over to her, and she cried, "My baby! My baby!" She was clenching her stomach. Now, shoot, accent. Hold on. Where was I? The ambulance attendant lifted her t-shirt, revealing a red
welt in the shape of a steering wheel on her abdomen. Parts of the welt were already turning purple, and Miss Taylor began to vomit. Ugh, that's kind of gross. Not gonna lie, that makes me want to throw up, to be honest. The EMTs placed Miss Taylor on a gurney and lifted her into an ambulance. They took her to Eastern Oklahoma Memorial Hospital in Vinita. That's I really am finna Google how to say this. This is really difficult. Where I understood her baby was born by C-section. It's so sad that the baby lived only 2 days after being born. Apparently, Miss Taylor was only 7 months into her pregnancy. I bet the baby would have lived if she had carried it to full term, instead of drinking, getting behind the wheel of a vehicle, and driving like a maniac. Ms. Taylor is to blame for the death of the baby. If she hadn't been drunk and swerving all over the road, she would never have been in that accident. Although she didn't test at .08 until over half an hour after the accident, I believe that either the first test was unreliable for some reason, or that she had drunk a beer immediately before the accident, and the alcohol had not yet metabolized. In any case, she was clearly impaired, and that impairment caused her to roll her vehicle, which led to the death of her baby. Driving impaired caused. Wait, I just said that. Driving under the influence of intoxicating liquor is a serious offense. Ms. Taylor put herself, her baby, and others at risk with reckless disregard for the law, and don't forget, she was just 17 at the time. That's below the legal drinking age, so she broke the law the second she consumed any alcohol. Some time in jail would give her an opportunity to think about what she did. Hopefully, she won't do it again, or at the very least, it will keep her off our roads. I know that the accident reconstruction person thinks that the wreck was because of the instability of the SUV Miss Taylor was driving. But I bought an ZG in 2016. At the time, both the 2015 and 2016 models had been redesigned to address problems that were identified as contributing to their whatever. They like to roll over. That's basically what it says. Here are the things I know about from my owner's manual and that were changed. The track was widened to 2.4 inches to give the G a squatter stance. I don't even know what that word means. A squatter stance and better stability. The front suspension A-arms were lengthened 1 inch to increase wheel travel. The front torsion bar spring rates were raised. The rear stability bar diameter was increased, and the stock absorbers were retuned. And I know for a fact that the National Highway Traffic Safety Administration recently denied a petition by Consumer Reports to open a defect investigation into the G. The NHTSA is a government agency of the U.S. Department of Transportation, responsible for the enforcement of all safety-related recalls notices that involve manufacturer defects affecting consumer vehicles. If they think the ZG is safe, then that's good enough for me. Witness ad amendum. I reviewed this statement and I have nothing significant to add. The material and facts are true and correct. Signed, Lieutenant Marty Pacheco. Pacheco. I still don't know how to say his name. Signed and sworn before me at 8 a.m. on the 31st day of October 2019. Molly Madison, Notary Public, State of Oklahoma, blah blah blah. Yay, we made it through another statement. Woo! Statement of Dakota Griffin, MD. I like how whenever they sign their names, they like Lieutenant, Mr. Lieutenant Boy puts LT as his signature. Alright. My name is Dakota Griffin, and I'm a doctor. I am a graduate of the University of Oklahoma and the Oklahoma College of Medicine. I did my residency at OU Medical Center in Oklahoma City, and after a 2-year fellowship at Emory University School of Medicine in Atlanta, Georgia, I returned to Oklahoma and to Eastern Oklahoma Memorial Hospital, where I've worked ever since, specializing in pediatric and emergency room medicine. I have always been very interested in does it say patrician? I'm pretty sure it says patricians, and in particular chromosomal abnormalities among children. I've conducted extensive research in the field, receiving grants for the General Clinical Research Centers, the Division of Research Resources, the National Institutes of Health, and the Christopher Tyler Harrison Research Fund. In addition to my work at the hospital, I teach a few classes at the Oklahoma College of Medicine. I have collaborated with the chair of the Department of Pediatricians in Emory, as well as the president of the John F. Kennedy Institute for Handicapped Children in Baltimore, Maryland, on several publications involving chromosomal abnormalities. Big boy words are coming up, boys. Chromosomes are tiny thread-like structures found within the human body cells. Each chromosome contains hundreds of genes that determine an individual's appearance and body functions. A human cell contains 22 pairs of chromosomes, which scientists have numbered 1 to 22. Each cell also contains a pair of sex chromosomes, which for a female is the XX chromosome. And for a male, the YX chromosome. The sex chromosome X is inherited from the mother, and the sex chromosome inherited from the father can be either X or female Y. Wait, no. Either an X female or a Y male. This chromosome determines the sex of the baby and is the 23rd pair in the cell. That means there are a total of 46 chromosomes in a normal human cell. I became even more interested in this subject with my sister Karen, and her husband gave birth to a daughter with trisomy 18, or Edwards syndrome. Children with trisomy have 47 chromosomes instead of 46. With trisomy 18, or I'm just going to say trisomy. I really don't care if I'm pronouncing this wrong or not. There are 3 of the 18th chromosome instead of 2. Other trisomy disorders include trisomy 21 or Down syndrome, where the 3rd chromosome is the 21st pair, and trisomy 13 or Patou's syndrome, in which the extra chromosome is the 13th pair. Because Karen was over 35, women over 35 have an increased risk of having a baby with a chromosome abnormality. At the time of her pregnancy, her that's a big word, obstetrician recommended prenatal prenatal testing. She and her husband agreed, so when she was 10 weeks along, her doctor conducted cryo oh cryo not cryonic why villus sampling. The test revealed that their baby was at risk for trisomy 18, and that's when the agony began. Immediately, her doctor counseled her about having an abortion. Oh, sure, he called it big words. Therapeutic. Oh, I'm an idiot. I can't read. Therapeutic termination. But everyone knows that means killing the fetus. I was very reluctant for my sister to make that decision. Although it's true I am pro-life, what is more important is that I am fully aware of that all abortions can create deep and this is an easy word I just can't read. Abdicating, emotional distress and guilt. However, none affects a woman as negatively as the type of convenience abortion Karen's doctor was recommending. For instance, Dr. David is a name, I don't have to pronounce it. PhD founder of the Elliott Institute for Post-Abortion Studies and authors of Aborted Women, Silent No More, has conducted research which found that women who underwent eugenic abortions have the most difficult time coping because they aborted babies who were wanted, at least babies who were wanted until it was discovered that they were going to be defective. You must remember, in a convenience abortion, that the woman knows that she and she alone is responsible for the death of her child, and researchers on the after effects of abortion have identified a pattern of psychological problems known as post-abortion syndrome, or PAS. PAS. Women suffering from PAS may experience drug or alcohol abuse, personal relationship disorders, sexual dysfunction, communication difficulties, damaged self-esteem, and even attempted suicide. Finally, other studies have shown that there is a high dang it, why can I freaking not read? Incidents, that's what it says. Okay. Or of marital separation or divorce after abortion. Naturally, I didn't want my sister and her husband to experience any of that. In my opinion, the prognosis regarding their child's potential life was poorly delivered by their physician. This complicated the decision-making process because they felt pressured to follow his recommendation rather than making their own choice. It is true that most trisomy babies are born with heart defects, respiratory problems, and physical abnormalities, but that doesn't make them any less valued as children. It is also true that the life dude, I know what the word is, I just can't freaking expectancy. Okay, there you go. Of babies born with trisomy 18 is not good. A study in clinical genetics conducted by Nestlin Goldstein in 1988 found that about 50% of babies died by 1 week and about 90% by 5 months. In that study, however, most of the babies were not prenatally okay, I'm pretty sure that means before pregnancy or before birth. I don't freaking know. Never mind. Diagnosed and therefore were cared for in the obster, obstetric and delivery room settings without knowledge of the diagnosis or prognosis. This could account for the low survival rates that conflict with the other studies which show that 45% of children born with trisomy 13 will die within the first month, and 70% of the survivors will die by 1 year. Cast in the movie cast in a more positive light, however, it can be said that 55% will live past the first month, and 30% will live past the first year. It is true that survival to adulthood is quite rare, but one adult is known to have survived at the age of 33. Most survivors have profound mental and physical disabilities. However, the capability for learning in children with Patau syndrome varies from case to case. Older children may be able to walk with or without a walker. They may also be able to understand words and phrases, follow simple commands, use a few words or signs, and recognize and interact with others. Besides the doom-saying doctor, there were also well-meaning family members and friends who told them it would be better if Karen had an abortion, and because they didn't need the burden of a handicapped child. It would have been easy for them to give into that kind of pressure, but I didn't let that happen. Thankfully, I was able to share my expertise about chromosomal disorders with them and persuade them that it is not only their right but also their duty to take care of the baby full term. I began by letting them know that they weren't alone in their situation. After all, a chromosomal defect of some types occurs approximately once in every 200 births, and the risk factor is the same for all parents. Furthermore, although there are no absolute statistics, it is estimated trisomy 21 occurs approximately once in every 700 births. Trisomy 18 once in every 1800 to 2000 births, and trisomy 13 once in every 2800 to 3000 births. In addition to there being plenty of people in the same boat, there are also support groups, internet chat rooms, and websites where families who have afflicted children get together and share information. The most well-known of these is the Support Organization for Trisomy 18, 13, and Related Disorders. It is a worldwide organization that began in 1979 and now has 10 international chapters as well as 57 here in the United States. The local chapters are run independent from state to state, allowing them to bring together family members and professionals for informal meetings. Imagine the comfort this brings to all parties. To be able to meet face to face with other parents who have similar experiences to share. I knew this would be one great interest to Karen, so I told her about it immediately and requested a new family information packet for her. Included in the packet were copies of recent newsletters, a booklet about common problems for babies with trisomy. I'm not even sure if that trisomy. I literally don't think that's how you say that, but alright. Fact sheets about trisomy 13 and 18, growth charts, expected developmental milestones, and an audio DVD. While I already knew all of the information contained in the packet, I wanted Karen and her husband to have tangible proof of the support network that was out there and that would be there for them and their baby. Through delivery, Karen's pregnancy was relatively uneventful. Then at birth, Daria, that's what they named their baby. had congestive heart failure, apnea, which means her breathing was interrupted for periods of time, and cleft lip. She also suffered from low birth weight and was born with her fists clenched, having her index finger overlapping third and fourth fingers. During the first months of her life, my sister and her husband learned how to manage tube feedings and oxygen masks, and they spent many all-night vigils at Daria's bedside. But she wasn't born blind or deaf like many trisomy 18 babies, so there was much for which we could be thankful. Most importantly, she had grown and flourished and is now nearly 4 years old. Although I already knew intellectually that all life is precious, my sister's experience really reinforced that for me. On the night of Miss Taylor's tragic automobile accident that led to the death of her baby, I was on duty in the emergency room at EOMH. When the ambulance arrived, she was wheeled immediately to the ER in a brief physical exam. I noted a bruise on her abdomen, which was consistent with her having been in an auto accident. She had a minor cut on her forehead, which a nurse cleaned and bandaged. Naturally, I was far more concerned about her and her baby than I was about a little scrape. I immediately ordered a transvaginal, easy words, transvaginal ultrasound probe, which confirmed pregnancy of approximately 28 weeks. The fetal heart rate was 130 and regular. Miss Taylor complained about abdominal and back pain. Although at the time there was no vaginal bleeding, the blood test revealed her BAC to be 0.08, over the legal limit, which no doubt led to her car wreck. I decided to admit her to the OB/GYN ward for further observation and fetal monitoring. About 6 hours later, Miss Taylor began to experience vaginal bleeding, and oh my god, there's still another page of this. Why? Miss Taylor began to experience vaginal bleeding, and fetal monitor the fetal monitor indicated that the baby was in distress. An ultrasound was performed, revealing the significant placenta abruption, one of the leading causes of fetal death in the third trimester. You see, the placenta transfers oxygen and nutrients from the mother's bloodstream to the baby and carries fetal waste products in the opposite direction. Abruption or separation of the prima refers to the separation of the placenta from the inner wall of the uterus before labor begins, which can decrease or interrupt the flow of oxygen-rich blood to the baby. Miss Taylor was quite lucky, you know. There is no clear diagnostic test for abruption, and it is not always observable through the ultrasound. In any event, I determined that the distress of the baby and the risk of the mother was severe enough that she should proceed with an emergency abdominal delivery or C-section. Oh boys, this is bad. The delivery went well, and Miss Taylor gave birth to a 4.5-pound baby boy. It was apparent upon delivery that the child may not have been perfectly formed. He had a moderately small head, known as microcephaly,
and I noticed that his forehead sloped. In addition, he experienced periods of interrupted breathing known as apnea, and his heart action was his heart his heart action was repetitively slow. We provided respiratory life support, and he was resurrected successfully. Because of the observed microcephaly, I ordered a CAT scan of his brain. Fortunately, he was not found to be holoprosenphyletic, which means his forehead and his brain had developed and divided properly. This was excellent news. Based upon his physical characteristics, a suspected trisomy, but only a chromosome analysis. I suspected a trisomy, but only a chromosome analysis could confirm that. He was transferred to the neonatal intensive care unit, where he remained on life support overnight. Over the course of the next 36 hours, baby Doe seemed to improve slightly, so we exuberated him. Yeah. He did well initially, but then he began to have repeated and prolonged periods of apnea. We resuscitated him on three more occasions, but on the fourth attempt, we were unable to bring him back. I ordered that a blood tissue sample be sent to a cryogenetics lab for testing. These tests are 99.9% accurate, but they take some time. The following day, I prepared a summary of the medical records of baby Doe, in which I set forth clearly in the information outlined above. I also explained my medical conclusion that the cause of death was prematurity. It was also my expert opinion that baby Doe had been given his rightful opportunity to remain in the womb for an additional 2 months. His physical condition would have dramatically improved. As it was, he was denied 24% of his time to grow and develop because his mother chose to drink and drive. The blunt force trauma to her abdomen that she sustained in the accident caused the placenta abruption. The placenta abruption then necessitated a premature delivery to protect both the child and the mother. I have no doubt whatsoever that Miss Taylor, and Miss Taylor alone, is responsible for the death of her mother. A few weeks later, I received the results of the cryogenic test, confirming that little baby Doe did in fact have trisomy 13. It is unfortunate because of the mother's total disregard for her child. There was no opportunity to see if he might have been among the 55% that lived past the first month, or maybe even the 33% who live past the first year and beyond. I reviewed the facts in the statement and I have nothing significant to add. The material and the facts are true. Whee! Now we get to move on to the statement of Logan Taylor. My name is Logan Taylor, and I am Kristen Taylor's brother/sister. We went to the same high school, even though we were in different grades. I say we went because Kristen graduated in May of 2018. Now she's at Stanford, and here I am, still stuck in the Big Cabin, Oklahoma. Kristen and I were always very close. It was very different. It was different from many sibling relationships where people are pretty close in age. I mean, we would do anything for each other. Anyway, I can't wait until I graduate, so I can move away from home and live on my own. Ever since Kristen ended up pregnant last year, my parents have been keeping me on a very short leash. I don't get to have a car or anything. They say if Kristen hadn't had a car, then she wouldn't have been running around and wouldn't have been getting pregnant and blah blah blah. I've told them a million times that Kristen wasn't running around. She was a good person who made one mistake. I'm not saying it wasn't a nightmare that Kristen got pregnant, because it definitely was. At the time, she was really on a roll, and getting pregnant could have ruined everything for her. At the time, she was the president of the student council at Roosevelt. She was in band, and she was a star on the track team. She was also the editor for the school newspaper and captain of the debate team. She had been accepted into to Stanford and had received a big fat scholarship from them. She was even named the salutatorian of her class. The principal asked her to step down when it became public knowledge that she was pregnant, but she refused, and he let it drop. She did have to cut way back on her school activities, but that was because our parents were trying really. They were trying to really keep her under their thumb. They didn't really need to do that though. I was with Kristen all of the time, and she would always behaved responsibly. I mean, the only times I wasn't with her was when she would drop me off at home after school, and then go to Francis Bacon's house to study. She isn't the brightest, and so Kristen would help him/her with math. And now, after all that help that Kristen gave Francis, wait, whatever, she is saying bad stuff about my sister. Well, Francis is nothing but a liar. I know my sister, and I know how much she cared about her baby. After all, she cared enough that she was willing to give it up for adoption, so it would have a good home with people who really had the ability to and the desire to take care of it. And she had a good reason for not going to the doctor until she was so far along. For the first 3 months that she had missed her period, Kristen didn't think anything of it. She was an athlete, so her period was always irregular. When she started to wonder if she might be pregnant, she panicked. The only doctor we knew was Dr. Garcia. He had been the family doctor for as long as I can remember. But Kristen was afraid that if she went to him and she was pregnant, he would tell her parents. In the end, she called Planned Parenthood, and they were able to recommend a clinic doctor who Kristen could see without our parents knowing. The doctor at the clinic confirmed that she was pregnant and estimated that she was about 4 months along. I don't know if Kristen would have considered having an abortion, but it didn't matter anyway, because she was past the time when she could have one. I also don't know if she would have considered keeping the baby if the father would have participated or helped out financially, or even just offered moral support and encouragement. But that was also irrelevant. That was irrelevant also because he didn't want anything to do with the child. She would never tell me, or anyone I don't think, who he was. But I have always thought it was Francis's brother, Kristen. Kristen loved Tony, and she would never have been unfaithful to him. Anyway, she tried to keep up with all her regular activities, and she did a great job as carrying on as if everything was just fine. But I know she was totally freaked out. I mean, who wouldn't be? Her whole future was ahead of her and looking great, and then her whole world got turned upside down because she ended up pregnant, and she basically had to deal with it all by herself. I know Francis and said she/he was a good friend to Kristen, but I disagree. She/he was just trying to get close to Kristen, so he/she and all the intimate details of what was going on, and spread it around their school. On May 29th, 2018, Blake Colvin, one of the graduates in Kristen's class, was having a party. Kristen decided to go to the party, and she invited me to go with her. I only saw Kristen drink 2 glasses of beer that night. I wasn't with her every second, but I was with her most of the time, and I would have known if she had gotten drunk. It really surprised me that she had any beer. She had never been the type to drink or smoke or anything like that. Running was too important to her.
I couldn't imagine she would do anything like that while she was pregnant, but I guess stress finally got to be too much, and she just gave in. Anyway, it was great to see her relax and have a good time. I couldn't remember the last time I saw her so animated. Her eyes were sparkling, she was laughing and singing and waving her arms around. She was even dancing. She had always liked dancing, and she was very good at it, like everything else she did. But this was the first time I had seen her dance since she got pregnant. Sometime around 10:30, a bunch of them, including Kristen, got kind of sentimental about graduation, and several of the girls were misty-eyed or crying. Then one of Kristen's friends suggested that they all drive to Grand Lake to watch the sunrise. I thought it was a dumb idea, and besides, I knew if they went there, I would probably be grounded for the rest of my life. Kristen wasn't worried about that, though. I mean, she was leaving for college in just a few months, so what could they really do to her? Anyway, Kristen dropped me off at home and then took all of her friends and took off to meet her friends. I told my parents where they were going and that they really didn't get mad. But then when my parents told me that Kristen had been in an accident, they were totally ticked and scared, and so was I. Scared, I mean. When they brought her home from the hospital, I could see that Kristen wasn't pregnant anymore. I asked where the baby was, and they told me that he had died. I can't believe that they charged my sister with a crime. They don't they think she feels bad enough? They said she was drunk or being a reckless driver, but I know that either of those things isn't true. I was with Kristen at the party, and she definitely wasn't drunk. And as for the reckless driving thing, Kristen hasn't been a wild driver since the time about a year and a half ago when my parents took her car away for 3 months because she got a bunch of speeding tickets. I reviewed this statement and I have nothing significant to add. The material and facts are true and the material facts are true and correct. Signed, Logan Taylor. Next statement. Oh no. 1, 2, 3, 4. Okay, it's not as long as the other ones. Wait, let me get my water actually. Where is it? Okay. Okay. Statement. Madison James, MD, PhD. My name is Madison James. I am an accident reconstruction expert. Expert. I live and work in Providence, Rhode Island. For several years before my current career, I was a private practice of medicine. As things turned out, however, being a physician just wasn't for me. I saw too many people die from illness or trauma, and I couldn't take the stress. I decided to get out of medicine and go back to school. I had always been fascinated with physics, so I pursued a degree in that, with the intention of becoming what is commonly called an accident reconstruction expert. I attended the University of Maine and received my PhD in physics in 1980. Since then, I have testified for the defense at 42 trials. I recall that one time I was hired by the plaintiff in a civil case, but once the attorneys heard of my expert opinions, I was told they would find someone else. I'm not sure why they didn't want me, but maybe it was because they thought I was biased and couldn't take the side of the person seeking damages. I've lectured. Yeah, I've lectured at the University of Pittsburgh, Rutgers University, and the Insurance Institute, and I've been hired by insurance companies to teach their adjusters. It's true that I am paid for my testimony, just like any other professional. My standard fee is $750 per hour, with a minimum of 10 hours retainer paid in advance. If those 10 hours are used, I charge $7,500 for the next 10 hours, and so on. To prepare for trial, I visited the accident scene and reviewed the accident report, breath analysis report and diagram of the accident scene that was as prepared by Lieutenant Pacheco. I don't know how you say it. Pacheco. Okay, I'm sorry. I couldn't help myself. And I reviewed a report on the Zuisu Gazelle SUVs, and I also spoke with the defendant, Kristen Taylor, for about 30 minutes. All of this led to me following the expert opinions. 1. Ms. Taylor was not intoxicated on May 29, 2018, at the time of her accident, and 2. Even if she were intoxicated, intoxication was not the cause of the accident. Instead, a sudden gust of wind pounded the Zuizu Gazelle as she headed onto a curve in the road, which caused her to swerve, lose control, and roll over. I am absolutely certain that Kristen Taylor was not intoxicated at the time of her accident. First of all, Ms. Taylor was obviously struck in her head, as was evidenced by the bleeding forehead noted in Lieutenant Pacheco's accident report. I believe her failure to pass the field sobriety test was her appearing dazed and confused, or because of the striking of her head. She suffered from a mild concussion. This would certainly amount to her staggering and not being able to touch her nose, or count to 10, or speak clearly. In addition, it is quite probable that she was in shock. As far as the results of L. Pacheco's breathalyzer tests go, I believe them to be suspect. Her breath alcohol concentrate. What am I doing? I can read. Her BAC was taken at 3 different times. The first reading was 0.04, well below the legal limit. 15 minutes later, it was 0.07, and immediately after that, it was 0.08, clearly demonstrating, as I shall explain in a moment, that Miss Taylor was below the legal limit of 0.08 at the time of the accident. How alcohol metabolizes in the body is quite fascinating. By that I mean, once alcohol is consumed, it is metabolized at a fairly constant rate. In addition, unit all of the alcohol leaves the stomach, the BAC will continue to increase. Only after it reaches the maximum BAC will it begin to decrease. Once that process begins, it drops at a relatively constant rate until all the alcohol has been metabolized. And if the individual ingests no additional alcohol, the BAC will eventually fall to 0.0. The breathalyzer test was given 3 times over the course of 1 hour. The first read 04, the next was 07, and the third was 08. This means that Miss Taylor still had alcohol in her stomach that had reached her bloodstream that had not reached her bloodstream until after the first test. What this means is that Miss Taylor's BAC at the time of her accident was not only below 08, it was beneath. I believe that 04 was not at the legal limit until the third breathalyzer test, which was well after the accident. That being the case, Miss Taylor was definitely not legally intoxicated when she lost. Miss Taylor was definitely not legally intoxicated when she lost control of the SUV. My second opinion is that Miss Taylor lost control of the SUV not because of having consumed intoxicating liquor, but because of the instability of the vehicle she was driving. Despite great advantages in safety technology, vehicles with higher ground clearance still pose higher rollover risk than vehicles that sit lower, because one of the key defining characteristics of sport utility vehicles, or SUVs,
is their great height. They are more likely to roll over in an accident than the passengers' cars. Unfortunately, technology cannot defy the laws of physics. These laws dictate that an object with a higher center of gravity is less stable and easier to topple over than an object of similar weight with a lower center of gravity. We all understand this concept intuitively. Prop open a block of wood lengthwise. Oh no. And it is easier to topple over with the push of a finger. Place it on its tall side to make it shorter, and it's far more difficult, maybe even impossible, to topple the same object. National Highway Transportation Safety Administration reports that fatalities due to rollovers are 2 to 3 times higher in SUVs than other passengers' vehicles, and the incidence of incapacitating injuries are 27.6% higher. A 2001 PBS Frontline program about SUVs vehicle rollover accidents amazed me that no one among the car makers, among the legislators, or among the researchers seemed to understand that very basic physics involved. In that Frontline program, they showed an expert from Ford combining a judge in a court case by informing him that Ford had fully analyzed the situation and they would widen their track of SUVs by 2 inches, and that where was I? By 2 inches, and that change would completely solve the problem. The judge seemed conformed. I think. I can't read. I'm stupid. But it's okay. But only because he didn't know about physics to realize that would produce a very minimal improvement and the basic danger would still remain. What needs to happen instead is using an extremely old technology of automatically changing the height of the vehicle suspension that was popular in luxury cars in the 1970s for leveling out the ride when the backseat riders were in the car. I see that as a simple and obvious solution for SUVs and other tall vehicles now. At low speeds like off-roading, the suspension could be as high as is popular on SUVs. But as a vehicle sensed greater road velocity as on a highway, the suspension could smoothly lower down to the height where the vehicle was far more stable and even unlikely to roll over. It wouldn't be very expensive to add to vehicles. It's an old and proven technology, and it would certainly save lives. Data collected by the Highway Loss Data Institute is similarly damning of 30 sport utility vehicles, models 1/3 and higher than average injury rates. In addition, some USVs have collision rates as much as 40% higher than the average. Generally, USV safety has been criticized because of the performance in situations drivers could face every day. For example, if someone was driving a station wagon and swerved sharply to avoid a child on a bike, the driver would be able to swerve quickly back onto his or her original course. If, however, the driver were operating an SUV, that sharp swerve would cause the vehicle to tip. It is true that the Suzuki Gazelle is not the only sport utility vehicle with problems. Sport utility vehicles greatly have the highest rate of deaths occurring in rollovers. Cars such as the Ford Explorer, Toyota 4Runner, Isuzu Rodeo, and Honda Passport have been in such involvement of SUV rollovers, and they have ended up in serious injury and death. SUV rollovers are almost 3 times more likely to occur than the average passenger car, and government tested indicate the most stable SUV is still more unstable than the most unstable car. Yeah, okay. In 1988 and again in 1996, the NHTSA turned down petitions for the Consumer Reports to investigate the Suzuki Samurai, a vehicle that not only showed serious rollover problems, but had also been involved in 147 deaths and 7,000 injuries. Most recently, however, Consumer Union petitioned the NHTSA to conduct a defect investigation of the 2015 and 2016 Gazelle and the Acura SLX, but the petition was denied in July of 2017. A statement issued by Dr. R. David Patel, Vice President and Technical Director of Consumers Union, the producer of Consumer Reports magazine, notes, NHTSA's refusal to grant our petition is the latest in a disturbing record of misguided decisions, in which the Federal Safety Agency has failed to protect consumers from rollover hazard. It is a serious setback for the nation's motorists. Suzuki, the manufacturer of Gazelle, claims that the NHTSA has vindicated the Gazelle, whatever the frick it's called. But the NHTSA has not done that, and the manufacturer's claims are seriously misleading. In denying the petition, NHTSA was not saying that Gazelle sells safe. It was only saying that they didn't expect that opening a defect investigation would lead into a formal recall. I've conducted a thorough analysis of the NHTSA decision and noted several major flaws in their work. They did not test the Gazelle against any other similar vehicles. When I observed the tests of the Gazelle and the SLX against other SUVs, it was apparent that the Gazelle uniquely performed in a hazardous way that most other SUVs do not. When as frequently as those I observed, I believe the NHTSA failed to take. Wait. Okay, I read that wrong. When the NHTSA repeated the tests of Gazelle, the agency also found tip-ups, although not as frequently as those I observed. I believe the NHTSA failed to take the tip-up seriously enough. Finally, I believe the NHTSA improperly discounted consumers' real-world experiences, as the agency said in its own decision. There were 36 customer complaints and some reported accidents relating to the instability of the Gazelle, even though the models in question have not been on the road for only 5 to 6 years. I disagree wholeheartedly with the NHTSA. Since 2012, I have observed the testing of 57 USVs minivans, and compact trucks on a special emergency handling course, and only the Giselle, Octura SLX, the Securi Samurai, and the Ford Bronco 2 have shown a significant tendency to tip up. To be sure of the results on the Giselle and the SLX, the tests were run 125 times at the speed of 36 miles per hour and above. And both vehicles tipped up 62 times with two wheels off the ground. This demonstrates phenomenal instability, and it is no wonder that the vehicles of Miss Taylor was driving rolled over. As I read the accident reports, Miss Taylor was traveling at a rate of around 80 miles per hour, barely 5 miles over the speed limit for that section of the turnpike. She was, however, at a point in the road where the highway curves. Lieutenant Pacheco said it was extremely windy. So windy, in fact, that it nearly knocked them over or down as they exited the police car. I believe that the combination of the entering the curve at around 80 miles per hour and being hit by a significant gust of wind from the north caused Ms. Taylor to lose control of her SUV. No doubt, as she answered, she overcompensated. No doubt, could not keep the vehicle on the highway, and it rolled over. Had she been driving a safer vehicle, or had there been no wind, I'm certain there would have been no accident. Although I couldn't find any conclusive information about the wind speed that evening, I would estimate from my review of weather reports and gusts that reached 40 to 50 miles per hour. The manufacturer has denied that Gazelle is in any way unsafe, saying that it meets all the federal established safety guidelines, and also know that they say 50 miles per hour wind could not affect it. But the report from the Automobile Consumer Utility Safety Department and the tests constructed by the Consumer Reports demonstrate otherwise, and the fact that the NHTSA refused to open a defect investigation of the Gazelle does not prove anything. They also refused petitions in 1989 and 1981 to investigate the Jeep CJ5, a vehicle with widely recognized tendency to roll. In addition, although the agency opened a limited investigation of the Ford Bronco 2, which was also involved in numerous rollover, it ended the investigation without taking action. In conclusion, I can only say that my expert opinion is Ms. Taylor's accident was caused solely by her driving a vehicle that had been repeatedly demonstrated to be unsafe. I reviewed the facts in the statement. I have nothing significant to add. The material facts are true and correct. Woo! I think this is the last one, right? Yeah. Last witness time, boys. Statement of Taylor McGraw, MD. My name is Taylor McGraw. I graduated from the University of Pennsylvania School of Medicine in 1995. I did my residency in Harvard, Connecticut, working on both the Harvard Medical Center and Harvard General Hospital in 1997. I applied and was accepted to Harvard's fellowship program in pediatrics. So I moved to Boston and began working at Children's Hospital. Although I was also working exclusively with children, my focus was in neurology. I finished my fellowship in 1999. Then I moved to Washington, D.C. and began working in the Department of neonatology at the Children's Hospital National Medical Center. While there, I became involved with the National Institute of Child Health and Human Development and the National Institute of Neurological Communicative Disorders and Stroke. I was part of an effort between the two to complete a joint assessment and prenatal and perinatal factors associated with brain disorders, which was eventually published in 2000. In 2005, I moved to Tulsa, Oklahoma, so I could become closer with my family. I began working with St. Peter Hospital upon relocating to Tulsa. Because of my combined training in pediatrics, and neurology, I spent a lot of time examining neurological dysfunction in children. In 2006, I started my own private practice, focusing on prenatal and perinatal causes of neurological dysfunction. I have reviewed the medical summary of Baby Doe, as prepared by Dr. Griffin. I disagree with his conclusion of that the baby died because of premarital resulting from her auto accident. In my expert opinion, Baby Doe died to his having a severe birth defect. As Dr. Griffin stated, Baby Doe has had what is referred to as trisomy 13 syndrome. A syndrome is a collection of signs and symptoms which together form an identifiable inherent abnormality. The term trisomy refers to the presence of a third or extra chromosome rather than the normal two in a chromosome pair. Dr. John Langdon Down first described trisomy 21 in 1866. However, it was not until 1959, when scientists were first able to see the chromosomes under a microscope, that Dr. Lejeune Paris was able to identify the third chromosome as that causes trisomy 21. Trisomy 13 is a syndrome that is caused by an extra 13th chromosome. It is also called Plateau syndrome after Dr. Claus Plateau, who first identified the extra chromosome and published a report describing trisomy 13. Similarly, trisomy 18 is caused by an extra 18th chromosome and is also called Edwards syndrome, after Dr. John Edwards, the doctor who identified and described this syndrome. Unlike other cells in the human body, when egg and sperm cells are produced, each pair of their chromosomes split into two and only one remains. This means that each ovum or egg could contain 23 of the mother's chromosomes, including the X sex chromosome, and 23 of the father's as well. A trisomy occurs when the parent's body produces sperm or eggs and a cell fails to divide properly, resulting in there being 3 identical chromosomes instead of 2. The cell that contains 24 chromosomes instead of 23 and at conception will create a single cell with 47 instead of the normal 46. To reiterate, trisomy 18 means that there are 3 of the number 18 chromosome. Trisomy 13 means that there are 3 of the number 13 chromosome, and so on. When it comes to chromosomes, more genetic material is not necessarily better. In the case of trisomy, the extra genetic material from the extra chromosome affects every state of the baby's development and growth, including the placenta, the umbilical cord, and so on. Trisomy 13 is a chromosomal abnormality. It occurs once in every 3,000 live babies, or live births. It is the third most known autosomal after trisomy 21 and trisomy 18, although not as well as muscular dystrophy. Infants affected with trisomy 13 tend to be small at birth. Spells of interrupted breathing or apnea in early infancy are frequent, and mental retardation is usually severe. Many affected children appear to be deaf, a moderately small head, or micro whatever, that's what I'm gonna say. With sloping foreheads and wide joints and openings between parietal bones are present in the body. Gross amniotic defects of the brain, especially holoprocephaly, or failure of the forehead to divide, are common. In addition, the entire eye is usually small, and colomboma, a defect of the iris tissue, and the retinal dysplasia, or faultily, I'm stupid. The development of the retina occur frequently. Cleft lip, cleft plate, or both are present in most cases. In addition, the ears are abnormally shaped and usually low set. Other symptoms include polydactyl, or extra fingers or toes, flexed fingers, and rounding one of the sole of the foot, known as the rocker bottom feet. There may also be loose folds of skin over the back of the neck and abnormal genitalia. In addition to those terrible physical abnormalities, 45% of the children with trisomy 13 die within the first 30 days of living. 70% of the survivors will die within their first birthday. While it is true that there are prenatal tests that can be performed to detect chromosomal problems, it is ridiculous to suggest that Miss Taylor in any way was irresponsible because she did not elect to have amniocentesis or chronic villus sampling, both of which are generally done at 10 to 12 weeks into the pregnancy. It is simply not reasonable for doctors to suggest genetic testing to everyone, and although the procedures are considered safe, there is a 1 in 200 risk of complications that can lead to a miscarriage. In a pregnant person as young as Miss Taylor, there was no reason to suspect that abnormalities existed. She was a healthy 17-year-old with no history of genetic disease in her family. Although this fact may be irrelevant because trisomy is not hereditary. In addition, the odds of women in their teens and 20s giving birth to children affected with trisomy are 1 in several thousand, and as compared with 1 in 20 women older than 45. In many cases, prenatal testing been performed and the trisomy 13 diagnosed, it is likely that Miss Taylor's physician would have counseled her about the possibility of therapeutic termination. It is, after all, part of physician's duty to identify a high-risk pregnancy, advise the mother of the facts and alternatives, and then discuss intervention if the mother so chooses. Since it was Miss Taylor's intention to give up her baby for adoption, it is unlikely that she would have elected to carry her baby to full term had she been possessed with all the facts. While I agree that with the information contained in Dr. Griffin's medical records for Kristen, Taylor, and baby Doe, I disagree completely with the conclusion about the cause of death. She concludes that baby Doe died as a result of the auto accident, which she says caused Miss Taylor to experience placemia abruption, or the premature separation of the placemia from the wall of the uterus. While there is no question that Miss Taylor suffered from placemia abruption, there is absolutely no medical evidence that it is caused by the car accident. There are a variety of reasons that placenta abruption occurs, ranging from cigarette smoking and hypertension to alcohol or drug use and premarital rupture of membranes. Only rarely does any sort of trauma or injury to the mother result in placemia abruption. In addition, the placemia abruption could easily have been present for some time. In the early stages, there may be no indication that it is occurring because it is extremely difficult to diagnose. Its symptoms are similar to several other conditions that happen during pregnancy. There are no clear diagnostic tests, and in fact, it is usually diagnosed by determining what it is not, rather than what it is. Although placental abruption always causes some bleeding, the blood may not always be apparent. Sometimes the middle portion of the placenta pulls away from the urine wall, leaving the outer margins and membranes attached. Blood can thus be trapped and concealed in a pocket. At other times, the baby's head or other body parts may be so tightly pressed against the wall or the uterus that the blood cannot make its way past. Dr. Griffin saw the baby upon birth and should have reasonably concluded from the baby's physical abnormalities that a trisomy was, at a minimum, highly probable. Instead, she concluded that Miss Taylor's auto accident was caused by the cause of the baby's death. Any competent physician would have drawn only a tentative conclusion about the cause of death, pending his or her receipt of the results of the chromosome analysis. In the laboratory, a culture is made and cells are grown. GOWN. I'm not sure if that's is a typo or if that's a real word. Are grown for a few days. They are collected and stained with a dye of inspection by a cryogenist. The chromosome analysis is highly specialized and is, as a rule, 99.9% accurate. The results of the analysis would have demonstrated that baby Doe was among the group of children who had very little chance of surviving to begin with, due to their being born with severe and life-threatening birth defects. The chromosome abnormality, when combined with the fact that the child was born 2 months early, was undoubtedly the cause of the baby's death. According to her/his own medical records, it was Dr. Griffin who made the decision to conduct an emergency C-section, the decision based upon the fact that the fetus was in significant distress, and at the least, according to the fetal monitoring, this being the case, the child had already experienced problems while still in the womb. Baby Doe would never have survived regardless of whether or not Kristen Taylor had been in an automobile accident or not. Oh wait, it just says automobile accident. Okay. I reviewed this statement and I have nothing significant to add. The material facts are true and correct. Signed, Taylor McGraw. I like how he didn't put MD after his, but Madison James put MD and PhD. The troll, dude. Alright, okay, so our first exhibit here is the official Oklahoma traffic collision report. It's just incident report, where it happened, all that stuff, all that jazz, with EMS, all that stuff, and then the officer, and then all this. Ooh, here we go. Ooh, big boy stuff. I wonder what they're gonna look like. I want to see this when it's printed out so I can tell. It says better. Okay. This is just more of the traffic collision report. There's so much. It's 4 pages long. Ooh, the map. Okay. So you see, she literally went to turn. Wait. Okay. How'd she? Well, I feel like it would be more like, but okay. I guess this makes no sense to me actually. What? So she drove, hit this barrier. I thought she rolled. How did she roll here? Is that what this is? Collision events. I can't read. This text is way too small in print. Okay. Alright. Next, Exhibit 2. Supplementary Offense Report. Offense, DUI. Case number VB 019, or maybe G-32. The victim, no victim, the subject, Mr. Lieutenant Pacheco. Why? That's. Oh. I'm really confused. Is this a 9 or is this a G? It looks like a 9. What kind of font? Why did they use such a weird font? Like, okay, alright, continuing. What is this? Is this Exhibit 3? Yes, it is. It's Exhibit 3 with, whatever this word means. Is Dakota Griffin's MD, my boys. Just with all this stuff. The resume of Madison James. This stuff is like such, dude, it's so bad, but at the same time, it's like, dude, it's gonna be so easy to enter. Automobile Consumer Utility Safety Department report. Yeah. Okay, it's just all the stuff. Resume of Taylor McGraw. Another freaking resume. I can't wait to make a timeline, dude. I swear, if we don't make a timeline, I'll be so angry. Extra of study. Whoops. Is that like stand for something, or what is this? I don't know. I don't know what that is. But that's the end. That's the end of all the exhibits.
I really don't want to go in detail to any of these because they're all the exhibits are so bad. Not even gonna lie. So yeah, that's all the exhibits. Hope you had a fun time listening to me read this. Pretty great. Loved it. Awesome. All right. Well, bye.